You want the jury to believe that you did your work and you came to your conclusions. You do not want the other attorney to make it sound like you are parroting the opinions that your attorney wants you to say. For example, Mr. Expert, did you discuss your testimony with anyone before coming into this room today? Answer, yes. Who would that be? I talked with Mr. Andrews, the defense counsel. What did he tell you to say? He told me to just truthfully answer the questions. And did you rehearse your testimony with him? No, but I did review my notes while preparing for my testimony. An observation here is that you listened carefully and you did not fall into the trap of agreeing that you were told to say anything, or that you rehearsed some predetermined and scripted set of responses. Let's talk about questions that try to set up conflicts with other authorities. An interesting gambit used by well-schooled attorneys is to find publications that you confirm are authoritative in your field. If you admit that a publication is authoritative, then you have given the other attorney the opportunity to quote absolutely anything they like from any page within that publication and possibly use it to contrast with one of your opinions. You will then have to explain why your opinion runs counter to what a recognized authority or authoritative journal in your field says. It will not matter that the quoted passage is out of context or even irrelevant to your case. What will matter is that you have already admitted blindly during testimony that a publication is a reliable authority and to be believed. How should you prepare in advance for this kind of question? Mr. Expert, I have here a copy of a well-known book or journal, they'll name it. Isn't it true that experts in your specialty regard this as an authoritative journal? Answer. Portions of that book or journal are authoritative, but I would have to look carefully at the section in which you may be interested. From time to time, this gambit may be applied to books or journals in which you yourself have been quoted as an expert in your field. Just because you know that a publication referred to you does not mean you should answer such a question any differently. Do not let your ego guide your response. The key tactic, then, is you still must hedge your response about any publication being a reliable authority in all that it might print. Let's talk about concession-type questions now. You are not a lawyer, but the opposing lawyer will be perfectly happy to have you weigh in on legal issues that may compromise your side of the case. If you are asked a question that contains anything that sounds like legal terminology, you should be cautious about responding with anything other than a request that the attorney explain the terms used. Before testifying, you should have a discussion with your retaining attorney about these legal issues that are involved, about the legal terminology that governs the issues, and any local jurisdictional standards that may apply to your testimony. This knowledge will be important for you to avoid getting trapped into admissions or concessions because of ignorance of the local and legal context. In addition to legal terminology and concessions that you may be tricked into giving, you have to be alert to innocuous-sounding agreement questions. In most cases, both attorneys know which facts are not disputed. Oftentimes, an opposing attorney will state a supposed fact and then ask you to agree with it. For example, the defendant programmed this system, isn't that true? Now, if you know the answers to questions like this, then you should have no problem answering it. The problems will occur when you assume a fact just because the opposing attorney convincingly states it. Anytime you are asked whether a statement is true or not, consider that a possible trick. You should be sure of the truth or falsity of each statement before you confirm with your answer that you accept it to be true. You will be more likely to avoid problems like this if you have a discussion before testimony about which facts in the case have been agreed on by both parties.